Dear students, hello. I am Sushim Shukla, Assistant Professor, School of Law and Legal Affairs, Noida International University. Today with you to discuss about the distribution of powers between central and state governments in India. Students, as you know that the distribution of powers is the basic characteristic of a federation. A federal constitution establishes a dual polity with the union at the center and states at periphery, and each enjoys sovereign powers within the allotted spheres by the Constitution of India. The basic principle of a federation is that the legislative, executive and financial authorities is divided between the central and state governments, and it is not by the law passed by the central government, but by the Constitution itself. Students, today we are going to discuss about the distribution of powers with the respect to the subject matters. As far as the nature of the distribution of powers is concerned, it varies according to the local and political background of a particular country. In America, the sovereign states which were keen to federate didn't like the complete subordination of the central government. Hence, they believed in entrusting the subjects of common interest with the central government and leaving the residuary powers with the states. And in Australia, they have followed the same pattern of the American Constitution, and it is of the single enumeration of powers, that is with the central government, and they also left the powers, residuary powers, with the state governments. In Canada, there is a double enumeration of powers, that is the federal and provincial, and in Canada the residuary powers are vested in the central government. Canadians were cautious about the unfortunate happenings in USA culminating in the War of 1891. The Canadians were aware about the shortcomings of a weak centre. The constitution framers of India followed the Canadian scheme of distribution of powers, obviously for opting a strong center. The Government of India Act 1935 introduced a threefold distribution of powers under federal, provincial and concurrent lists. The present Constitution of India has followed the concept of the Government of India Act 1935 and provided this distribution of powers under the three lists that was provided under the Schedule 7 of the Indian Constitution. Article 246 of Indian Constitution lays down the laws which are made by the Parliament and state legislature. Under Article 246 Clause 1 of the Indian Constitution, the Parliament is exclusively empowered to frame laws with respect to the subject matters which are enumerated in list first under the Schedule 7 of Indian Constitution. This list first is known as the Union List, and this Union List consists of 97 subjects, and all these 97 subjects are of national importance, like external affairs, railways, etc. Under Article 246 Clause 2, the Parliament and legislature of each state is empowered to frame the laws for the subject matters which are enumerated in list third of the Constitution of India provided under Schedule 7. This list third is also known as the concurrent list, and this list consists of 47 subjects, and upon these 47 subjects both the central and state governments are empowered to frame the laws, like preventive detention laws, legal and medical profession, bankruptcy, newspapers and electricity, etc. Under Article 246 Clause 3, the legislature of each of the state is empowered to frame the laws for such state or any part of that particular state for with the respect of those subject matters which are included in list second of the Constitution of India provided under Schedule 7. This list second is known as state list. This state list consists of 66 subjects, and all these 66 subjects are of local importance, like public order, police and local governments. Now students, coming on the residuary powers, under Article 248 of Indian Constitution, the residuary powers are vested in the Parliament. Entry 97 of the Union List lays down that the Parliament is exclusively empowered to frame laws with respect of those subject matters which are not mentioned in a state list or concurrent list, and it also includes the taxes which are not included in either of these two lists. Now coming on the interpretation of these three lists, as we have studied that there is a distribution of powers between central and state governments, and they cannot frame the laws beyond those allotted spheres to them. However, it is quite clear that a scientific distribution of powers is quite impossible. Here a question constantly arises that a particular subject, whether a particular subject matter falls in the sphere of one government or the other. For these type of problems in a federal constitution, the Supreme Court is duty bound to resolve these type of problems. In India, the Supreme Court has evolved different types of principles to deal with these types of problems. Firstly, I would like to talk about the predominance of the lists. Under Indian Constitution, the Union List is predominant over the state list and concurrent list, and the concurrent list is predominant over the laws of the state list. Now coming on the doctrines which are laid down by the Honorable Supreme Court to deal with these types of problems. The doctrine of pith and substance. This doctrine, under this doctrine of pith and substance, the courts generally consider the true object of the legislation, whether the legislature is competent to make it or not. It is very well established by the Honorable Supreme Court in Prafulla Kumar Mukherjee versus Bank of Khulna. Now the doctrine of colorable legislation. No legislature can violate the constitutional prohibitions by applying indirect methods. The whole doctrine of colorable legislation is based on the maxim that you cannot do indirectly what you cannot do directly. This doctrine has been discussed in detail by the Supreme Court in the case of State of Bihar versus Kameswar Singh. Now we are going to discuss about the repugnancy between the laws. Under Article 254 Clause 1 of Indian Constitution, the laws for the repugnancy are discussed. This Article 254 Clause 1 applies only where there is a repugnancy between the laws made by the state government and the central government on a particular subject matter which is enumerated in the concurrent list. If a law framed by the state legislature is inconsistent with the law framed by the parliament upon the same subject matter which is enumerated in the concurrent list, then the law framed by the central government will prevail and the law framed by the state government will be void to the extent of repugnancy. The Constitution of India also provides certain types of conditions under which the Parliament is empowered to frame the laws on the subject matters which are enumerated in state list. These conditions are: under Article 249 of the Constitution of India, Parliament is empowered to frame the laws in national interest upon those subject matters which are mentioned in a state list. It is only when the Rajya Sabha passes a resolution by 2/3 majority of the members present and voting. And in under Article 250, the Parliament is empowered to frame the law on the subject matter of a state list during the proclamation of emergency. Under Article 252, if the states provides their consent to the Parliament, then Parliament can also frame the laws on a particular subject matter which is enumerated in state list. Under Article 253 of the Constitution of India, the Parliament is empowered to frame the law on the subject matter included in a state list to give effect to international treaties and agreements. And the Parliament of India is also empowered to frame the laws on the subject matters of the state list in the case where the constitutional machinery has been failed. By the impression of this study we can say that Indian constitution is a federal constitution with a strong centralizing tendency. Dear students, it is over for today, and in next lecture we will also discuss about the distribution of legislative powers according to the territorial jurisdiction. Thank you so much.